In this video, I'm going to be talking to you about the most important law in the United States. Without it, the internet would not exist as it does today. YouTube would not exist today. The law is Section 230 of the Communications Decency Act. And in this video, we're going to be covering what Section 230 of the Communications Decency Act is, why the law is so important, what legal defenses are available to internet service providers under the CDA, what civil claims and exceptions to the CDA are available under the Act and through other court rulings, and who can be held liable if an internet service provider cannot, as well as the arguments for and against amending the CDA in the future. And we are starting right now. Hi, I'm Aaron Mink, attorney and founder of Mink Law, the nation's leading law firm when it comes to dealing with internet defamation and online harassment. If you like this video and want to learn more about protecting your brand online, hit the subscribe button below and ring that bell so you don't miss a thing. Section 230 of the Communications Decency Act is a U.S. law passed by Congress in 1996 as part of Title V of the Telecommunications Act. At its core, Section 230 provides that no provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider. A mouthful, I know. What this means is that online service providers that host or republish other people's content and speech are protected from civil lawsuits and liability that might otherwise be used to hold them legally responsible for what others say and do on their platforms. The CDA also provides something called a Good Samaritan protection clause that allows platforms to remove or moderate third-party content that they deem to be obscene or offensive, even if it's constitutionally protected speech, as long as they do so in good faith. The CDA applies to most all online websites, including social media platforms like Facebook, Twitter, Google, and LinkedIn. Really, any online service or website that publishes third-party content is covered. Section 230 is considered one of the most important internet laws that we have today. It has been credited as being the 26 words that created the internet. If Section 230 didn't exist, websites like Facebook, Twitter, Reddit, and even Google probably wouldn't exist either. These platforms have billions of users and pieces of content published to them every single day. It's just not reasonable to expect that websites can review everything that's published on them and to be able to hold them accountable for their users' content and bad behavior. If this was the case, these platforms and services just would not exist today. They would be immediately sued into oblivion, or it would incentivize companies to heavily regulate and censor their content. The internet that we've grown to know and love simply would not exist as it does today if there was no CDA. The CDA is the only safeguard that stops that from happening. Internet service providers can claim two types of immunity under Section 230 as defenses to civil lawsuits. First, ISPs can argue that they qualify for CDA protection if they are sued for any claims that treat them as a publisher of information provided by third parties. This defense provides immunity from dozens of different types of civil claims, including defamation, false advertising, unfair competition, intentional infliction of emotional distress, and invasion of privacy, among others. But in reality, the CDA can apply to any claim. If a civil claim will hold an internet service provider liable for the publication of third-party content, the website is completely immune from liability. Period. Second, ISPs are immune from any civil claims involving an ISP's decision to remove or moderate content that they find in good faith to be obscene, lewd, lascivious, filthy, excessively violent, harassing, or otherwise objectionable, whether or not such material is constitutionally protected or not. What this means is that websites basically have the ability to remove and moderate content published to their platform however they want to with impunity. The only requirement is that they do so in good faith. This means that an ISP can't remove or moderate content with an intent to defraud or facilitate illegal activity. However, that is an extremely easy bar to meet, so they're immune. Although protections available to internet service providers under Section 230 are extremely broad, immunity under the CDA is not unlimited. The Communications Decency Act provides 5 specific exceptions where internet service providers can be held liable. These exceptions include 1. Federal criminal liability. ISPs that commit a federal crime cannot claim immunity under the CDA. 2. Violations of a law called the Electronic Communications Privacy Act, which is a law that protects how electronic communications and private data collected by a website about their users may be stored and disclosed to third parties in the government in response to search warrants and subpoenas. 3. Intellectual property claims, claims for copyright infringement, patent infringement, and trademark infringement, among others, are not protected under the CDA. 4. There's also no immunity from state laws that are consistent with Section 230. So state criminal laws, intellectual property laws, and other laws that just don't hold ISPs liable for third-party content are allowable. And lastly, as a direct response to cases upholding Section 230 immunity for websites like Backpage.com and other parts of Craigslist that were believed to be aiding and abetting online sex trafficking, Congress signed the Allow States and Victims to Fight Online Sex Trafficking Act, also called FOSTA, in 2017, which amends the CDA so that ISPs can be held liable for claims relating to the promotion or facilitation of prostitution and sex trafficking. There are also several other exceptions to Section 230 of the Communications Decency Act that are not contained in the statute directly, but have developed in common law rulings by federal courts. Courts have found that Section 230 immunity does not apply where an internet service provider is directly involved with the unlawful activity at issue. For example, if an ISP edits a published statement or materially alters its meaning, and then the altered statement is considered defamatory, then the ISP would not be immune from a claim under the CDA for defamation. Likewise, courts have found that if an ISP creates or develops illegal activity, they cannot claim CDA immunity. Another exception is if an ISP makes a legally enforceable promise to remove content and then fails to follow through on its promise. Failure to do so has been found to waive a website's immunity under Section 230 in some cases. Lastly, a couple of courts have found that CDA protections may not apply in cases involving claims for product liability. In 2019, the Third Circuit Court of Appeals held that in the case of Oberdorf v. Amazon.com, that negligence and strict liability claims based on defective products sold on Amazon.com did not qualify for CDA protections, but those claims are very limited. You might be asking, if a website can't be held liable for defamatory or harassing unlawful behavior of its users, who can? The answer is the user who published the libelous content or engaged in unlawful behavior is the person who's liable. If a defamatory statement was posted on Facebook, for example, the Facebook user who posted is liable and can be sued. Facebook cannot. Now, bringing a claim against authors of unlawful content can be difficult, particularly if the person who posted content or engaged in unlawful behavior did so anonymously. In this situation, you have to file something called a John Doe lawsuit and subpoena the internet service provider where the anonymous user provided identifying information to register their account. This can include the user's name, email address, telephone number, IP addresses associated with their logins. This is something that my firm has a lot of experience in. If you are interested in learning more about John Doe lawsuits, I've left some links below to my firm's website where you can learn more about the process. Section 230 is considered to be a very controversial law because it provides internet service providers immunity at the expense of people who often suffer very real harm from the actions of third parties who use the ISP services. Supporters of Section 230 argue that the means justify the ends for 5 main reasons. Number 1, the CDA protects free speech rights on the internet. Number 2, it prevents ISPs from censoring user speech unnecessarily. 3, it allows for innovation by minimizing the cost platforms would have to incur by engaging in lengthy litigation for millions of unmeritorious claims they would undoubtedly be hit with without the CDA. 4, it encourages internet service providers to self-regulate content without being pressured by the threat of litigation, which leads to better user experience. And 5, it provides a single, all-encompassing defense of immunity to a myriad of potential legal claims, which allows courts to dispose of these lawsuits quickly, so they do not overly burden our country's courts and legal systems. Now, opponents of Section 230 argue that it should be changed and amended for 3 main reasons. Because 1, it leaves many people with meritorious claims and serious harm with limited or no other means of recovering for injuries suffered as a result of unlawful conduct online. 2, opponents believe that courts have interpreted the CDA to apply too broadly in protecting internet service providers, and that the law has applied to things it wasn't designed to protect, and it has been used to facilitate illegal activity outside of the internet. And 3, opponents believe it promotes and facilitates harassment and other unlawful forms of speech and behavior that normally would not be legally protected. Well, that's all the time that I have today. If you have questions that I didn't address, leave a comment below, and I'll do my best to respond as soon as I can. If you like this video and want to learn more about how you can protect your brand from online defamation and harassment, make sure to click the subscribe button below so you can catch all our videos that we come out with. This is Aaron Mink of Mink Law, and I will see you in the next video.